Welcome back, ladies and gentlemen. I hope that you are doing as fantastic as I am. We have gotten into the second hour. We are actually just a minute to the second hour of the show, and we are about to start the conversation, the very important conversation that we have actually we want to work on understanding intellectual property. And I am actually being told that that is just the tip of the iceberg, but worry not, because Lilian is here to help us do just that. Good morning.
Good morning.
How are you doing?
I'm fine, thank you. How are you?
I'm good. I want you to say hi to guys at home. Just tell us
hi,
who you
everyone.
do. What do you do?
Okay, so my name is Lilian Njeri. I'm an advocate of the High Court of Kenya.
Yeah.
I'm a legal officer at a company called MedSurg Healthcare,
Yes.
and I also have a private practice. So I have specialized in international commercial law and intellectual property.
Yeah.
But when you are an advocate of the High Court of Kenya,
Yeah.
under the mandate of the laws in Kenya,
Yeah.
you can practice any law. So I can do any law, but what I've mastered it is
Yes.
international commercial law and intellectual property.
Yes.
Yes.
So basically, when you want to practice to be a lawyer, you can practice any
Yes.
law as allowed by the Constitution.
As long as you are an advocate of the High Court of Kenya.
As long as you are an advocate of the High Court of Kenya.
Yes.
So you can do a lot, but you have chosen
Yes.
to work on
To study on that
yes.
and to work on that.
Yes,
Yes.
exactly.
Yeah.
I like that. So
Yes.
how did you end up there? Now that you have the liberty of choosing any law, why were you interested in intellectual property law, and just basically exactly what you do?
For me, I'm very interested in art. And when you talk about intellectual property, as I was telling you earlier,
Yes.
it's not limited to just art. It's
Yes.
limited to technology. For example, the person who makes certain apps that are on your phone,
Yes.
that person had to have their right protected under a different type of intellectual property.
Yes.
So it promotes a lot of innovation, and I was fascinated that it's not just a corporate thing.
Yes.
It's something that can affect you and me.
Exactly.
For example,
on
a daily basis.
Yes.
For example, if I wanted to create a fashion brand and I wanted to have a certain logo,
Yes.
or certain colors
Yes.
that denote that this is my fashion brand,
Exactly.
that is a type of intellectual property. So it's very fascinating.
Yes.
And it involves our everyday interactions
Yes.
when it comes to innovation, art, and technology.
Yeah.
So
and
I was fascinated by
far
that.
and wide.
Yes.
Like it's a lot now. Thank you for that clarification. I hope you guys have already started taking your pen and paper, because you will need it. You will need it, because I thought that takes me back to certain companies that even have a certain color, a certain
Yes.
a certain type
Logo.
of green,
Yes.
or a certain type of red that is just specifically to them.
Yes.
So that means that is protected for them.
So another thing with intellectual property, it has to be, by the reason why it's called intellectual property, it's a tangible right.
Yes.
But that tangible right has to first of all have some sort of innovation,
Yes.
creativity, and originality.
Yes.
So you can't.
So I can just go and say purple today.
So I think
want
this green
exactly
is mine.
Yes.
It has to have some sort of creativity, that distinguishes it from another
Yes.
type of
green or another type
logo
of,
or mark.
logo, exactly.
You understand?
Yes.
For example, you can have an intellectual property on a design of a bottle. So
okay.
it's not just that it's a name or a logo.
Yes.
It also falls within the terms of, they're called design,
Yes.
model designs,
Yeah.
utility designs.
Yes.
You can have an intellectual property on a process of maybe how you've made a medication.
Yes. Okay.
So you might not get the right to exclusively have a license to only have that medicine.
Yes.
But you can, for example, patent the process you use to make that medication.
Yes.
Does that make sense?
Yes,
like
it
the
does.
COVID vaccine.
Yes.
Exactly. The reason why it was patented is scientists went to the lab, discovered that if they mixed this and this components,
product A and product B,
yes, even if these components were naturally occurring,
Yes.
it's their ability
Yes.
and their research that made them arrive to that, for example, vaccine.
Exactly.
And so they were able to patent that and have some. No, patent is another type of intellectual property.
Yes. So in
Mm-hmm.
layman's language, there has to be a uniqueness and creativity
and originality.
Yes. To whatever it is that you want
protected.
to protect.
Yes.
Okay. All right.
And secondly, it has to be in writing.
Yes.
You can't keep it as an idea. You can't say it's my idea in my head, and then when someone starts using it, you say, "Oh, that was my idea." It has to be in writing. Yes.
Okay. So artists, you can just have a song in your head and think that's okay. Someone else you will talk to a friend, and then information moves.
Yes.
So it has to be in writing.
Yes.
I think that's a good foundation. That's a good foundation of a place where we can start.
Yes.
So now let's break down from intellectual property because that's broader and get to artists. Artists in terms of singers, songwriters, playwriters, artists like this playwrights, artists like this ones of ours who are drawing. Let's get down to them.
Yes.
What is their kind of protection called?
So the type of protection is called copyright, and in Kenya we have two laws that protect that. There's a Copyright Act Kenya, and there's a new one that has been created recently called the Copyright Amendment Act, which is just giving some few amendments to the original copyright. So the Copyright Act protects works for people such as drawers, musicians, music producers, performers, actors, artists, like drawers, computer software, and anything that qualifies as literal work. That means even writers of a book.
Okay.
Yes.
Okay.
Yes.
So
yes.
in art in general, art in every aspect that you could think of is covered under copyright. Exactly.
Yes.
So let's start from the basics because I feel artists need to understand this. What is copywriting? Let's start there.
So copywriting is a process where you register your right to be protected under the copyright legislation in Kenya.
Yes.
So as long as you're the creator of whatever art that you possess, and you can sufficiently defend that you have made some sort of alteration to the art or some sort of originality to it, and it's in writing, then you are eligible to have your art protected under copyright.
Exactly.
Yes.
Okay, now step number 2. Can, like we were talking just before the interview, can one say creative, like say a song, can one song be copyrighted by or have been protected by different people?
Yes. So when it comes to a song, it is created in different ways. So I can use, for example, let me use an artist like Mariah. Mariah is an artist and a songwriter. So the act of singing is different from the act of writing the lyrics of that song, and it's different from the act of producing that song into a physical manifestation where it's recorded into a sound recording. That's completely different. And it's also different when you go to a concert and perform that song.
Okay. I think I told you we need notebooks. I told you that you need notebooks because this is the same song. The only person you probably know is Mariah
or Rihanna
to say, but this song was written by a different person. This song was produced by a different producer. Rihanna came to Africa and performed that song at a concert, and all those can be protected separately. So who is copywriting?
So like I said, when you're a musician, it's very important to understand first of all the type of contract you're getting into. So if, for example, you're a songwriter, then you have more rights because on top of the performance rights, which is you performing that song, you also have the rights to the lyrics of the song. That means if your song is taken by another person and altered or used in another manner that is not what you wanted, then you can file an infringement against that person because you own the lyrics of the song. Exactly. Or if I'm the music producer and I made the beats. So what music producers do is they make the beats of a song. If someone else comes and takes those beats or rhythms and uses them without my consent, then I
You have the right.
I have a right, an infringement.
Yes, an infringement.
So it depends on what contribution you've made to the song. If your contribution is performance only, then you have performance rights. If your contribution is lyrics, which is the words of a song, then you have the lyrical right and the performance rights. If you created everything, for example, a very interesting very vast songwriter and singer is Neo. Neo writes his song, he produces his song, and he performs his song. So that type of artist would have a very higher level of using his work. That means there's no one who can steal his beats without his permission. No one can steal his lyrics without his permission, and no one can adapt his performance and infringe without permission. And he has all those three rights, which he can have protected. Does that make sense?
He can protect all of them. Which means if you need to do anything, absolutely anything with Neo's song, you need to talk to him. You need his permission in order to do that. So I think as a Kenyan industry where we are at, we are not even fighting about who wrote the music and then who performed the music. It's about my song or my work being used by another person separately from what I created. You know, like I think we are yet to get there, but I have had very few cases of, say, a producer saying the beats of this song. We have had a number of cases, so we are going to talk about it. But this of the first party, the creator of the song, gave us a beautiful song, and then this song is being used elsewhere. How far do my rights go? Like, I have created my own music. Let's say I'm Neo. So how far do my rights go as far as other people using my song?
So, for example, if I've created the beats, then you can't use those beats on another song without my consent. You can't say you're remixing. You can't record yourself dancing to that song without my consent. You can't play that song, for example, in a public place like a mall, hospital. Any place that's deemed public. By public, I mean it's frequented by other people of the general public. You can't use that song without my consent. You can't play the recording, for example, in your shop without my consent.
So
also you can't have broadcasting houses using your song without your consent.
Without my consent. I think the broadcasting houses, that part we have covered. That part I know in Kenya is very like that is black and white. You know, you're not supposed to play a musician song. You know, like you can just go and get someone's song and play it in here. But a question, who gives the consent?
So under the Copyright Act of Kenya, there's a body called the Kenya Copyright Board, and it's mandated to license societies that will which can act on behalf of artists to collect royalties and to monitor their works. So it is not a compulsory membership, it's voluntary. And the three organizations that have been given their licenses by the Kenya Copyright Board are the Music Copyright Society of Kenya, the Performance Rights Society of Kenya, and the Kenya Association of Music Producers. So these three boards offer different types of licenses. So like I mentioned, the Kenya Association of Music Producers, by the name of it, it applies to persons who have work creations of art, for example, of making the music by way of beats, rhythms, and arranging the musicality of that song. So if you want to a song, and if you have a song and the majority of the work has been done by a music producer, you need to get a license from the Kenya Association of Music Producers. If you're a performer and maybe someone wants to take a performance you've done, like a video,
a music video that you have done,
a music video of a performance you have done, you'd need a license from the Performance Rights Institute. Society of Kenya. Now, what all these three organizations have done, they've come together and provided a joint license, so that you don't need to go to the three of them to get three different types of licenses. Because, for example, if I take a song and I play it on audio, and then I decide I'm going to record myself dancing to that song, and I only get one license from the Music Society of Kenya, I will have violated the performance rights because I've recorded myself in that video. That's a different license.
That's a different license.
You don't have a recording license.
Yes.
You don't have a right to record yourself dancing to my music. Maybe you only have a right to the audio, playing the audio version, the music version only. So what they've done, they've come together and decided they'll provide something called a joint license. It will cover everything from mechanical recording of a song. For example, you can take a song and record it in your CD. Or for example, changing it mechanically by way of, for example, DJing. You can also record yourself dancing to it. For example, what Sauti Sol was claiming Raila didn't get was a synchronization license, which is getting a license when you're doing any form of videotaping or like I said, physical activity on video. So when you go to the website, it will tell you that you just need a joint license and you pay via M-Pesa. And once you get that, then you'll have fulfilled all the requirements for using a song in any form that is audio, visual, synchronization, or mechanical recording. So in short, they have made it easy for you to get an umbrella license.
License for all these things. Now that you have mentioned it, make us understand exactly why Sauti Sol had an issue per se. Like what specifically what right of theirs was violated?
The right. So what Azimio got was an public communication to the public license, which was only covering audio play. So playing the song, but not recording it on tape. If you play a song and you record it on tape, that's a different kind of license that you need, and that license is called a synchronization license. If you play a song, record it on tape, or put it on YouTube, that's a different kind of license, which is also called synchronization. As long as you don't get a license for video recording, but you only got one license for audio play, then you're violating their rights. So if you go to the website, Kenya Copyright Board clarified that and said what they should have gotten is a synchronization license. But under the joint license now, it will be covering that.
They will have everything covered.
There will be a joint, there will be a synchronization license, an audio license, a right to mechanically record that song. For example, like I was saying, DJing. Or formatting it in a way that is maybe creating a playlist. You understand?
Exactly.
So under that joint license, that's what Azimio should have gotten.
A
joint license, which has, for example, a synchronization license.
So okay, now we understand exactly where the problem was, because I think so many artists, and especially in this political era that we are in, a lot of music is going to be used for artists, and I think they need to understand exactly what does the other party need to get in order to actually play our music or have our music playing. I hope that has been clarified enough for you guys at home. Then the next one would be, when is the time to copyright? I am just an artist, I have one song, or I am just going to stage my first play. When is the time to copyright?
So the best time to copyright is as soon as you've put it into writing, because like I said, intellectual property only operates if it's materially put into writing. An idea cannot be copyrighted. Just because you have it in your mind doesn't mean that you have a right to have it protected. So as long as you can qualify those two things to show some sort of novelty, creativity, or originality, and have it in writing, then present it to the copyright offices, and what they'll do, they'll investigate to make sure that maybe you're not you've not stolen some work and saying that it's yours, or you've not just taken someone else's work and just plagiarized it and just changed a few sentences and then you're trying to sell it off as yours. And then another thing you need to understand, copyrights only exist for 50 years. So after the ending of 50 years, you have to renew that license. Yes.
Okay, but I think 50 years is pretty fair.
It is pretty fair.
Yes.
If
you're renewing it after 50 years, that will mean it has given you, but why not for life though?
Because, like I said, human beings, we don't exist in a vacuum. So there's a need for innovation. Maybe someone might read your book and get inspired, and it would be unjust to forbid. For example, if you look at Shakespeare's books, if they were copyrighted for life, maybe we wouldn't have had access to have them, to read them, and to even get inspiration and adapt them into movies. So I think under the law, it's deemed as fair that after 50 years, like you said, you'd have gotten any economic advantage you wanted or sort of protection from alteration or using it in a manner that you're not you're not okay with.
So, and there is still a chance to renew it.
There's still a chance to renew it. It's not that after 50 years you cannot renew it. So after 50 years, it subsides. If you don't renew it, then it goes into something that is public. But if after 50 years you continue to renew it, for example, a lot of Disney movies are from books that were copyrighted. So you'll find they keep renewing after 50 years. You can still renew.
Beauty and the Beast. I think that has been the longest that I know. So they keep renewing it because their families follow up on
maybe they have an estate that takes care of that.
Okay.
For example, even music, if we were not able to access some of the music of persons who've passed away, I think would miss a lot in art. For example, Michael Jackson, when he passed away, what if his estate decided they're going to restrict everyone from using their music in any adaptation, even in movies? I think it would be quite unjust to art. So as long as you can renew it, then it gives you some like sort of right to maintain, to have control over it. And that's
so is that provision given, like the way you have documents saying next of kin, or like you were saying the estate, they have the permission to renew? So is this provided before, like when I'm getting the first license? Do I provide that information or much later?
So what happens is when you protect that right, it will go into the registry, and as long as it's 50 years have not subsided, it will be there. So now if you pass away, what happens? You go into a process called succession, and depending whether you had a will or not, copyright is a property. It's a property right. So that will go into what is called your estate. Now, if you have a will, probably you'll have said in this will, this is what I want with my copyright. If you don't have a will, the law has a way to make sure that this continuation of rights continues. Now that will depend on the estate, the persons who are next of kin, what they decide to do with your estate.
Your copyright. Okay, all right. I like that. I think artists in the house have learned a thing or two. I know they are listening, and I know they have learned one or two things. Then the next question would be, moving on, how do you copyright, say, plays, performances, a performance that you did, or even okay, let's answer that before we go to the next question, which is closely related. But how do you copyright such, now that this is not music, this is a play that you were part of, or this is a performance that you did?
So you're a performer. When you're a performer, there are certain things that you've done in a performance. For example, you danced, and that was reduced into some sort of tangible. Another thing about copyright, it has to be protected in some sort of tangible way. That's why it's either in writing or now in performances, it will be in the visual, in the audiovisual.
Or
audiovisual form. So that audiovisual form is what you will have protected, that no person can go into that audio visual and alter it without my consent, or use it without my consent.
Yes, but isn't this violated all the time? Like, I mean, the number of times I find Beyonce's performances in other websites or in other places in YouTube. Does that mean they have gotten permission for that?
Yes. For example, YouTube as a platform has to get these rights, performance rights of like the video of maybe Beyonce's music. They have to get permission. As long as it's in a platform like YouTube, there's a very high chance that they've gotten permission, like a license to upload such videos.
Exactly.
Yes.
Okay, I like, so platforms like YouTube are helpful because they cannot allow you to earn monetary value from a video that has not been.
And if you try and put something that doesn't have, for example, a license, YouTube sometimes will flag you.
Yes,
or if you for example plagiarize someone's content, like you copy, there are people who have had their content struck down in YouTube.
Okay, I like, so such platforms are helping. Okay, then now how do you copyright a line, sipangwingwi, and someone puts that in their song, or some famous, some parting shot that you usually have as an artist or not an artist? Can you copyright? Do you have a right to a certain something that you came up with creatively and then people picked it up? Is there a way to copyright?
So when you're talking about, for example, a phrase, that will fall in another different kind of intellectual property, because when we talk about copyright, it's specifically for literal work, musical works, performance art, computer softwares, and anything that involves literal work. So, for example, sipangwingwi, it's a phrase that will go under trademark. Now, for something to be eligible for trademark, it has to be unique. It has to be not the ordinary use of a language, or language or word. For example, you can't copyright the word good because everyone uses it's in a language. So if you copyright good, that means we can't use good in our sentences. You understand? Second of all, you have to when you want to trademark something, it has to be for the purpose, for some use. You can't trademark a phrase if you're not going to use it. Then that's misuse of law. For example, sipangwingwi, if you want to use that, for example, to make merchandise, like on t-shirts, bags, or any other merchandising that you have, then that's possible. But you can't take a phrase and then trademark it for no use.
For the sake of this is mine. Also, you have to prove that you are going to use it.
Yes. So and it has to be unique. It can't be the ordinary use of just the English word or the Kiswahili word. And it has to have some sort of use for it. Otherwise, if we are granted the permission to just trademark any phrase,
everything.
Exactly.
And then we will have start having
it will be
left,
unreasonable,
right, and center claiming. So it has to be unique. And you have to provide some use for it. So you can't just say I have copyrighted this, or I have this is mine, without making it, without showing that you have a use for that.
it.
So I think that we have understood.
And for that, it's under trademark, not copyright.
So that is under trademark.
Okay.
Guys, I hope that you're getting
trademark law deals with the protection of logos, catchphrases, words, marks, or anything that is in a phrase that can denote some sort of uniqueness for a certain use.
And so that is why it is not an infringement to anyone if, say, t-shirts, like you print a t-shirt with the word sipangwingu, it's not exactly an infringement of any right, because this cannot be copyrighted. It has not met the criteria for copywriting. I hope that you guys are getting that, for trademarking rather. So is there a website or a place where you can go and see if a certain work has been copyrighted or not?
So under the Kenya Copyrights Board, I mentioned they keep a register. So this register has the data for everything that has been copyrighted. So if you need to access it, you can go to their website, or you can email them, or you can go to their offices, which are in Nairobi, to make sure. Or for example, if you want to make a copyright application, they'll definitely go through the register to make sure that there's no collusion or there's no colliding of copyrights. So there's a register of all the copyrighted material.
That you can actually go and check, and which is where they go to if you send your own kind of, anything that you want to copyright or trademark. So they still go to the same register to confirm. But you also can. Okay. Is this where we have cases of someone is coming to copyright way later, like when there are already so many issues, so many duplicates that have been done, but they did not copyright their work? So is that where the issues come from?
So your question is, for example, you had some work and you didn't copyright it.
And then someone else used my work. Now I am wondering, who gets the right of copywriting there?
So the priority is the first person to copyright gets the first right. But if you can prove that this person stole your work, then you have the right to have your work reinstated as you being the owner. But like I said, if you have an idea and you don't copyright it, you don't reduce it in writing and protect it, then the law follows the first person to register is the priority and is deemed to be the first person to have registered it.
Unless you can prove it, which is a whole long process. So as we started by saying, copyright your work as soon as you have it in writing, or as soon as you have a tangible way of showing this is unique, this is my own creation. Okay, let's go to artists, our drawers, pencil artists. How do they copyright their work?
So their work falls under drawings, still under copyright. So the same criteria, show some novelty. For example, you cannot draw Mona Lisa and then go try and copyright it. It has to, you have to show some sort of novelty, originality, creativity. As long as you can show that, then your work is eligible. Just
so
to register it.
This would be my question. There are hundreds, if not thousands, of pencil artists, and you will find some of these art pieces are, say, an over the sea kind of drawing, or sunrise, or sunset. Like there are so many, there are so many of such drawings. Can you really be able to patent? Can you prove originality in a drawing of something that is common? That's what I'm saying. Not Mona Lisa, of course, but sunrise, sunset, palm trees by the beach. Something that you will think is very common.
So I think what an artist would do to show some sort of creativity, maybe the way they use the type of even paint they use, the strokes, the design of how they draw. For example, if I draw a seaside, and if you draw a seaside and I draw a seaside, there's a way I can make my work distinguishable from yours. I can use maybe a different type of way or a different type of painting to make sure that whenever I draw my work, you'll be able to tell that it's my work.
It is your work.
Does that make sense?
Okay.
For example, there are people who draw pencil, and the way they draw is maybe they draw with dots. That's some sort of uniqueness. For you, maybe use strokes. That's some sort of uniqueness. So as long as you can show that you've added some creativity, then your work can be distinguishable from another person.
Okay, now moving on from that, from a professional point of view, what are some of the advantages, because I know they are there and they are major, of an artist, any type of artist copywriting their work? Like, why go through all the hassle?
First of all, there's the issue of the economic benefit. For example, this is your livelihood. And if you haven't copyrighted it, you're missing out on, for example, if you haven't issued licenses to a broadcasting house. Every time a radio plays your song, you're supposed to maybe get some royalty if you've copyrighted it. If you don't have a copyright, you're missing out on that. For example, this campaign's going on. If you've not copyrighted your work and the politicians use your music or your art in any form, you're missing out on that. So like any other property, for example, if you have land, you want to get some economic benefits from it. Intellectual property is still some type of property. You want to at least get some remuneration from it. So that's one of the advantages. The second advantage is protecting your art. You work very hard.
True. Every day you are in the
to create whatever that you're doing. So it would be a disservice to you if someone comes and alters it or uses it without your permission and even sells and uses it as if it's yours. There's an issue of recognition. You want to be recognized
for the work that I did,
that you've done, and the hard work that you've done. So it would be unfair if we didn't have copyright to protect now such people. There's also the moral issue. It's me who has gone through, like I was saying, you've worked hard. You spend a lot of money, you spend a lot of time. It's your passion, it's your gift. So it's not morally okay for someone to plagiarize, for example, your work.
And just go with it. Okay, I think there are people who we haven't touched, book writers, and people who have composed books or have poems that they have put together. Which part of copyright do they fall under?
They still fall under copyright. So copyright protects literal works.
We started by saying. So let me know, in a book, like I have written a book, say about, we were here last Monday talking about freedom. There are 100 other books that have been written about freedom. How do I prove my work to be unique?
So first of all, like I said, you have to prove that your work is original. You haven't plagiarized. So you can't read someone's book and then duplicate that information in your book and say, oh, I just changed maybe one chapter. That wouldn't be fair. You have to show what creativity have you put. For you, maybe you spoke about freedom from the perspective of maybe a young boy, or freedom from a perspective of you are maybe a woman, or freedom from the perspective of you are a politician. So you have to show, like I said, you have to show some sort of novelty or contribution that you've made to the book, and obviously make sure that you've not plagiarized someone else's book.
Of course, rules of plagiarizing, not copy pasting people's work in the name of research.
And you have to reduce it into writing. So you can't keep it in your head.
Exactly. Okay. She keeps reminding us that you cannot copyright ideas in your head. So tell us, as Kenyan artists, who do we go to, or what is the right way of reporting an infringement, and how do you go about that?
So if you're under any of the societies I've listed, the Performance Rights Society of Kenya, the Kenya Association of Music Producers, and the Music Copyright Society of Kenya. They, under the Copyright Act, there are people who monitor public places, online content, and any other public domain on the use of copyright. So these officers work with the Kenya police, and they can, for example, they have the right to inspect and even confiscate material that has been copyrighted. Now, if you're not a member of those, or for example, you're not able to go to every single shop and find who's like playing your song without copyright. For example, you see your song in an advert and they didn't get your permission. They don't have a license. There's a copyright tribunal. So it's mandated to hear such disputes, and if you are not satisfied or you want to appeal from the Copyright Tribunal, you can go to the High Court of Kenya.
So you can, just like any other case, like any other infringement, personal space, a lot of things, property, you can just
first go to the Copyright Tribunal.
Copyright Tribunal. If you're not satisfied, you can
appeal it to the High Court of Kenya.
The High Court of Kenya to get your
prayers, remedies.
Then, because this has been an issue since time immemorial, like I think I remember growing up, the issue was piracy. people selling CDs of musicians that they have not been allowed to sell.
Yes.
What is exactly the issue with our artists in Kenya specifically and copyright? Where do you feel the issue is? Is it lack of information, or is it like, what exactly is the problem?
I think the issue is lack of, I think people have not been sensitized enough. There's lack of information dissemination.
Yeah.
So, for example, all these societies exist.
Yes.
And if you go to their website, they give you even the procedure of joining them, of seeking remedies. And if you also go to the copyright, for example, when it comes to piracy, it provides the provision of what is piracy and what are the consequences of people who infringe on your copyright. So I think the biggest issue is lack of information and lack of understanding.
Yes.
For example, as an artist, for you think as long as I'm performing and I'm getting money, then that's fine.
Exactly.
But there are so many other avenues that maybe your rights are being infringed, which you could curb if you knew this information.
Exactly.
Yes.
Okay, so now you know where to seek for help. You know what you can be able to do. So all this information is at your fingertips, because if it's a website, you just need to Google or even just ask how to go on if my rights have been infringed on, and I'm sure that website will appear somewhere somehow.
Yes.
So you as an advocate, how do you come in all these matters, copywriting, patenting, intellectual property in general?
So if you wanted your works, for example, copyrighted, as an advocate, I'd help you go through the application by making sure you're eligible. For example, if you, like you said, you have a song, I'd want to know, are you the composer of the song, or are you just the singer of the song? Are you the lyricist of the song? So that to know what exactly we are protecting. So that's why I come in as an advocate, because I can distinguish the level of rights that you have. And then I'd be able to present it in a prescribed form to the Kenya Copyright Board. For them to go through and also confirm that what we are presenting is true. So also another reason why you'd need an advocate is when there's an infringement. For example, you might not be able to distinguish what is a synchronizing license when your copyright is being infringed. For example, you only gave the audio license. You didn't know that you needed a license when someone is recording themselves on YouTube. That's why I come in as an advocate. The third thing is, if you have an infringement and you want to go to the Copyright Tribunal, then you would require my services to advocate for you, to represent you and make sure that I'm representing your interest in a manner that is much more prescribed in law. Maybe you might not be able to understand the technical terms. So this is why I come in to interpret and represent you.
And you represent both individuals and corporates. Corporates, to be able to put it in simple terms of what they want and what the law requires of them. What are some parts of the constitution that artists can actually go to see exactly where copyright is stated and to understand better about intellectual property in Kenya specifically?
So intellectual property is deemed as a property right, and under Article 40 of the Constitution, it protects the rights of property owners. Now that's where the Copyright Act derives its mandate. So Article 40 of the Constitution.
Article 40 of the Constitution. Please go there and read it carefully. I like the Constitution because it's normally very clearly outlined. If not, you can also get an advocate to help you, understand what is happening in there. Okay, the other question would be, because we started with financial issues, how much does it cost to copyright?
So it depends on the type of copyright. If you go to the website, click on how to register a copyright, it will, and you present your papers, it will tell you how much, and also when you go to the Kenya Copyright Board, they'll tell you how much you'd need to pay. So I don't think there's a standard payment for your copyright, because they're different. So it depends on what you're copywriting and what the board will assess and determine how much you'll pay.
Exactly.
Yes.
Okay. And then that we're still talking about matters finances. Royalties. Who determines how much my royalties cost? Because if a specific party decides to give me 2,000 shillings, like how can an artist follow up on
royalties?
Yes, on royalties.
So, for example, let's use a song.
Yes.
Because it's one of the most contentious one.
Yes.
For example, you've given a broadcasting body a license to play your songs.
Yes.
So what happens is the more your song is played, the more you get.
Yes.
So if your song is not played, you will get a standard small fee of your royalty by the virtue of you having an existing copyright. But the more your song play, it's a play to play ratio. So the more your song is played, the more you get your royalties.
Yes. And what are the standard? Like, let's talk bare minimum and say your song is just been played kidogo too. Like, is there a way an artist can contribute or like monitor as to how much the basic is?
Basic in terms of what
royalties, in terms of what they will get back. So
it's an agreement between the different societies and the artist. Actually, now the people who collect these royalties under the new Kenya Copyright Amendment Act is KRA. So KRA will be collecting on your behalf because it's still some sort of income, so you have to pay taxes on it.
Yes. So
once you get your royalty, they remit their taxes and then give it back to you.
So it goes first to KRA.
Yes, KRA is KRA is the one now collecting the royalties under the new Kenya Copyright Amendment Act.
Yes. Okay. Then let's talk about the Amendment Act that you told me about. One, when is it being implemented, or has it already been implemented?
It hasn't been implemented, but it's already in law. That means it's operational and it can be used when there's any conflict.
Okay. In case of conflict, that can be used.
Yes.
Any advantage in the amendment for an artist?
So, yes.
Yeah.
One of the changes is the royalties have changed from 20% to 51%.
Okay.
So there's an increase in the percentage of royalties that artists are getting.
Okay.
The other thing is the establishment of the Kenya Copyright Tribunal. I mean, the Copyright Tribunal. Before that, you had to go to court, but now with the tribunal, you can go to the tribunal.
Specifically to the tribunal.
The Copyright Tribunal, before you even go to court. Another thing, it's included computer software to be protected as copyright. Computer software is a very popular form of technology that has really accelerated in Kenya. We're talking the creation of these apps we see. So that has been included in the Kenya Copyright the Amendment Act. The only contentious clause that has been put is the internet service providers. So internet service providers, for example, Safaricom, Airtel, they're allowed to store music or allow you to access music, but they're not allowed to influence their customers to play certain music. They are not allowed to alter that music in any way. All they're supposed to do is provide internet services for you to access music.
Okay.
Another thing is, if you feel like any of the internet service providers is infringing on your copyright, you can institute a takedown procedure. This is, you inform them that they're infringing on your rights by written form, and by virtue of that they can take down whatever song they've put there if you feel like they're infringing on their rights. So that's another advantage. If you feel like any internet service provider is infringing on your rights, for example, as a musician, there's a procedure for them to take down,
for them to actually take it down. Okay, we talked about softwares. Does this include mobile apps?
Yes.
Because now I know there are a lot of so many mobile apps that are dealing with different things, from finances to exercise. So that means you can be able to copyright it. And the rules still apply. If you have a computer software, you have to show there's some novelty and originality, uniqueness and creativity, and then it has to be in writing.
Simple.
Okay.
Yeah.
And I'm amazing. I hope you guys are learning a thing or two.
Yeah.
There's someone who is asking, Moremi Njeri, I think is just insisting or asking on what we have been answering. He's saying, good morning, art and culture, representing Kama Kawaida. She's asking at Lilian, so for anything to be regarded as a copyright, it has to be written down.
Yes.
I think we agreed that it has to be written down. And if it is in or video form, you have to present like that video format of it. So in short, you have to have something to show.
Yes, it has to be in tangible form.
Yes, tangible.
So copyright or intellectual property does not protect ideas.
Yes.
It has to be in a tangible form.
Exactly.
Yes.
I think because you will be looking for her, telling her how your idea has been.
No.
Yes. So it has to be in a tangible form.
Yes.
All right. I think that is about it. I don't think there is anything that I have not touched on.
Yes.
Is there anything that you feel like you can add to it, like to generally to artists? What do you think they should know as an advocate?
For me, just to insist on just visiting this website. They are very, very legible and accessible, and they use very simple English. So you as an artist, even if you don't have someone with any like legal knowledge, if you go to the website, they give you a procedure, even how to join this organization, the process of paying, how you get your royalties. They have a section called frequently asked questions of what maybe artists normally face, like I've not been receiving my royalties. They'll tell you the procedure. So I would insist on people doing that.
Please do that. I see the questions are trickling in. Moyaki Maora is asking, what about protection of pictures? Now, I'm thinking this is, photographers.
Photographers,
yes,
like I said.
Think that is what, I hope that's what you mean. If not, please clarify. Yes.
So, for a picture to be copyrighted, first of all, you have to be the creator of that picture. By creator, I mean you're the one who took that picture.
Yes.
So, if a paparazzi takes a picture of you, that's not your picture. That's their picture. The picture belongs to the person who took that photo. Secondly, like I said, copyright has to be in tangible form. So you have to produce it in a tangible manner. Secondly, the reason why photos are important, the celebrities normally have a lot of issues when their photos are taken without authority.
Yes, because that would be the follow-up question.
Yes.
What is my right as a subject? Now that I'm not the one who took the pictures, but I am the subject of the photo. How does that?
The law is quite ambiguous. It will look at, for example, you're a celebrity. It's ordinary that your photos are taken. But that doesn't give someone a right to take a photo of you that would cause some sort of damage, emotional damage, or even economic damage. For example, if you're, sorry to use this example, breastfeeding, and a paparazzi takes a photo of you and slams it on a magazine. That is a violation of my right to privacy.
Yes, exactly.
Then I would have a right to that. To have that photo taken down. If they take a photo of me, maybe in a position that maybe violates my, like my dignity, like maybe it shows some like material that I don't want to be seen, then you have a right to have that photo taken down, because I also have a right to dignity.
Exactly.
So it depends on, also, you're a celebrity. The more you're a celebrity, the less rights you have of your photos taken by a paparazzi. The more private you are, the more private citizen you are, the more rights you have to have your photos not taken by anyone that is not you.
Exactly.
Yes.
Okay, so then what are the rights? I think we didn't finish answering on what is the right of this person who's taken a photo, and not necessarily of a person. It could be of a different subject. Like, where do these photographers come in? Of your building, like my producer is saying to my ear, or of a forest, like, different photos, like their creativity is taking pictures. Where do they have their
first of all protected? For example, I have a right to my property. You cannot come to my property and start taking photos of my property. That's a violation of my right to privacy. So there's also a provision for taking photos for government and government-owned land and government-owned like parastatals. You can't go to State House and start taking photos. Yes, that's a violation of security and also a violation of taking. It's against the. And they
even
rules.
Have those signages
no photographs taken.
Photos allowed.
But if you're in a forest, for example, and you want to take the photos of the trees, then that's okay.
So then I can protect. Can I protect those pictures?
If you can show that there's some sort of originality or creativity that you did that makes them unique from another photo of the same.
Yes. Okay.
Yes.
So the uniqueness is very heavy when photography is concerned.
Yes. Maybe you modified it. Maybe you have certain like apps that you use that modifies the photos you take. For example, there are a lot of like celebrity photographers or just photographers in general. There's a way, if I take a photo, because I'm not a photographer, and for example you're a photographer, you know exactly how to take a photo, you know the settings to use to exaggerate something, so that if I take a photo of maybe this moon and I take a photo of the moon, there will be a clear distinct difference between the two
photos. Yes. Okay. What of these GIFs, GIFs and memes and just like maybe a short recorded clip of me saying something, then that was put into memes. Can I be able to say I do not want to be I do not want to be used in memes. I do not want this video clip of mine to be used as a meme or as a GIF, or do I have rights to that?
So there was a time there was a GIF of this American girl, and she complained that she had some sort of disability, and a photo of her was being used in different memes. Now, when it comes to memes, it also depends. The more public it's become, the less likely you have the rights to, but it does not keep you out of trying to stop the use of that meme as if you can, for example, show there's some sort of damage, like emotional damage or some sort of financial loss that you've incurred because of people using such a meme, or the people who took your photo didn't have a right.
Yes. Okay. So then I want us to try and clarify where the line is in these things. My producer is reminding me of another scenario. Like we see in newspapers where artists are using political satire, to talk about money, the money laundering, stealing, money was stolen, and they use certain pictures of politicians per se. Where is the line? Where can a politician say no, that is, they have crossed the line?
So when it comes to copyright, there are defenses to it. For example, when it's called fair use. If you use any literary work or music or audiovisual to ridicule, critique, or sort of make some sort of comparison, then you are not infringing on copyright.
Okay. So
for example, it's called fair use. For example, in that, like you're saying in the newspaper, they're using maybe the pictures or like a caricature to criticize a certain politician, then that's not an infringement of copyright.
Okay. I hope they are listening and that they know that, because some of them are fine, but some of them you start feeling like, if I was like kama wanapita mahali. Finally, where can people find you? Because of course you are an advocate of the High Court. She can practice practically any law that she wants to do, and if you're an artist and maybe you are having an issue or you would like some clarification, you would like her services, where can they find you?
So you can find me on LinkedIn. My name is Lilian Kamwan on LinkedIn, and also I'm gonna leave my business card with my my number. I work in Museum Hill Center. It's on Muthithi Road, Westlands.
Okay, so you can reach out to me. I can give you her contacts. In short, that is what we can be able to do. Thank you so much. Thank you so much, Lilian. It's been a pleasure. I think we have learned more than we have done in 1 hour what you can do in 3 months practically to start sorting out matters intellectual property. This was technically a masterclass, and that was really, really amazing. Thank you so much. It was such a pleasure to have you here.
Thank you.
Would you say hi to someone? You want to say hi to someone on television?
No, I'm quite shy.
She will say hi next time. All right.
Yeah.
Thank you so much, ladies and gentlemen. That was Matters Intellectual Property. Please feel free to still keep your questions coming. If I can get to Lilian or get an answer to them, I'll answer them before the end of the show. But as we get to the top of the hour, that is where we close our lounge number 1. Don't worry, we still have a full hour as an artist waiting to keep you entertained. So stick around. This is Art and Culture Monday with me, Karen Blessing.